Morrison v. Olson is a Supreme Court decision that was a result of the Watergate scandal to some extent. Watergate, and in particular the Saturday Night Massacre incident, made people worry that the executive branch just isn't capable of adequately policing and investigating itself. In other words, the federal prosecutors at the Department of Justice and in all of its U.S. attorney offices around the country, they are part of the executive branch, and maybe they just inevitably won't be as aggressive as they should be about going after crimes that are committed by important people within the executive branch. And so, in the aftermath of Watergate, Congress enacted a new law providing for the appointment of independent counsel. In this case, the independent counsel happened to be investigating Ted Olson, who would go on to be a famous conservative lawyer. He was the Solicitor General of the United States at one point, among other things. This independent counsel scheme certainly involves quite a mixing or sharing of executive and judicial authority. The Attorney General is involved at the start because he assesses the need for the independent counsel, but then a special court actually selects the independent counsel. And then once the independent counsel gets going, the Attorney General can remove him for good cause, or the special court can terminate the independent counsel's assignment if the judges think the task they assigned him to do is substantially completed. So this seems like a novel blend of executive and judicial power. They're basically creating a new position that's arising in part from the executive branch and in part from the judicial branch. The Supreme Court decides that this is acceptable. This is very much a question of separation of powers. How should authority be allocated among the three branches of the national government? There are two major approaches that have been taken to these kinds of issues. One is called the formalist approach. Under the formalist approach, you assume that the Constitution was meant to create three separate, distinct branches, with each having its own separate, exclusive sphere of authority. It's like three separate baskets, and they really should be kept as separate as possible. And so you would approve an intermingling or sharing of their powers only when it's something that was specifically allowed in the Constitution. So, for example, the Constitution clearly says that both Congress and the President have a role to play in enacting legislation. Congress passes legislation, the President can sign it or veto it, the President can override the veto. So that sort of thing is fine. But other than that, the powers of the three branches should be kept totally separate. So the formalist approach is meant to be very mechanical, very rigid. When in doubt, keep the powers separate. On the other hand, the functionalist approach says actually this dimension of constitutional law is more complicated than that. The framers weren't that obsessed with separation of powers. They really weren't trying to split the powers into three separate baskets. They were instead creating a system, like a machine, with three interrelated parts. They could have just split the powers so that each branch had nothing to do with the others, but instead they created a system of checks and balances, with each branch having powers that mesh with those of the other branches. So under this view, you shouldn't be so quick to jump to the conclusion that separating the powers is the best thing to do. Instead, you should look at each particular issue, each particular situation, and see what's at stake. What branches are involved? What are they trying to do? What are the advantages of letting them work together? For example, would it be a lot more efficient to let them work together on a particular thing rather than forcing them to stay apart? What might be the disadvantages or the risks if they share the particular responsibility for something? Would anything bad really happen if they're not kept separated? The two approaches basically start with different presumptions. The formalist approach presumes that things should be separate unless the Constitution clearly says otherwise. And the functionalist approach has the opposite presumption. It presumes that if Congress and the President chose to arrange something in a certain way, they probably had a good reason. There was probably some advantage to be gained by it, and so the court should defer to that unless it really poses a clear danger in some way. The two approaches are also based on different assumptions about why the framers of the Constitution wanted to have a separation of powers in the first place. Formalists would emphasize the idea that the framers were trying to limit government power and slow down the use of it. They were intentionally making the three branches or categories of power very separate in order to make it hard for the government to do things, so the government wouldn't become too powerful or too big or too far-reaching. On the other hand, functionalists would say that the purpose of the separation of powers doctrine was to promote smooth functioning of the government. It was just a division of labor. It made sense for each branch to specialize in a certain thing because that would be more efficient. But whenever it would be more efficient to mix the powers together, that's fine. In addition, these two approaches also reflect the very basic question that you see running throughout law about whether it's better to have rigid rules or flexible standards. The formalist approach gives you the certainty and the clarity of firm categorical rules. And on the other hand, the functionalist approach gives you the flexibility to decide issues on a case-by-case basis. And so in part, this issue comes down to how well you think judges will do at deciding separation of powers issues if they have more flexibility and discretion. If you feel that, look, judges are not political scientists, and they're not likely to do a great job of predicting the future effects of various arrangements of government power, then you'd want to go with the formalist view and give the judges a simple, clear rule to apply. And on the other hand, if you're more confident that the judges can make good assessments of the virtues or risks of particular situations, then go with the functionalist approach and trust the judges to make good calls about particular situations. The majority opinion in Morrison v. Olson is a very clear example of the functionalist approach. Certainly there's some mixing of executive and judicial power here, and it's not something that was specifically addressed by the Constitution, and yet the Supreme Court doesn't automatically say that makes it invalid. Instead, they seem to be weighing the particular circumstances and saying, well, it's a matter of degree. They say that the special judicial court's ability to terminate a special prosecutor's assignment may encroach somewhat upon executive power, but it's not a significant encroachment. They say it poses some threat of judicial intrusion upon executive branch authority, but it's not a sufficient threat to make it invalid. They say that the president doesn't really have complete control over the independent counsel because he can't fire the independent counsel at will, but still the president's got sufficient control. Sure, there's some sacrifice of executive branch power here, but it's not something so central to the functioning of the executive branch as to make it invalid. In other words, it's close enough. There's some mixing and sharing of the branch's power here, but it's not too bad. It's okay. Justice Scalia, on the other hand, in his dissent, goes with a much more formalistic approach. He says this case is easy. Investigating and prosecuting crimes, that is clearly an executive power. It is quintessentially executive activity, as he puts it. And here, has that executive power been left entirely and exclusively in the hands of the executive branch? Well, no. It's been put in the hands of this semi-executive, semi-judicial, independent counsel person who's not under the complete control of the executive branch. So you've got executive power that's not completely in the hands of the executive branch. And in Scalia's view, that's automatically unconstitutional. Period. End of story. And the court shouldn't be balancing and weighing and deciding how much is too much. As Scalia puts it, it is not for us to determine, and we have never presumed to determine, how much of the purely executive powers of government must be within the full control of the president. The Constitution prescribes that they all are. And that's a perfect statement of the formalistic approach. Scalia goes on to describe this independent counsel thing as a pretty scary scenario. He says, look, they appoint some guy to investigate you, and they give him an unlimited budget and an indefinite amount of time to just go after you. And if he abuses his power, he doesn't pay any price for it because he's not elected. He doesn't work for anybody who is elected. He's an independent counsel, so he doesn't have to answer to anybody. Normally if prosecutors go around making terrible decisions, people are going to hold it against the president, and he'll pay a political price for that. But the independent counsel doesn't have to answer to the president, so potentially he could do anything, and nobody can tell him to cool it. So we've got two very different visions here. We've got the specter of the Saturday Night Massacre on one side with corruption and abuses occurring and nobody having the independence to really do anything about it. And on the other side, we've got this image of the independent prosecutor who's out of control and abusing his power, and nobody can rein him in because of his special independence from the normal lines of authority within the government. So which side is more persuasive? Well, people's attitudes toward independent counsels tend to vary a lot depending on who's being investigated. Originally, the independent counsel statute was the Democrats' idea. They controlled Congress in the late 1970s, and they enacted this in response to Watergate. The statute was used only once during Jimmy Carter's presidency. He was a Democrat. They were investigating alleged cocaine use by his chief of staff. And then it was used about 5 times to investigate various folks in the Reagan administration, which is a Republican administration. And then it was used about 5 more times during the Clinton administration. The most famous of those was independent counsel Ken Starr's investigation of President Clinton, which started out being about the Whitewater real estate deal, but eventually grew into the Monica Lewinsky scandal, and Clinton wound up being impeached for it. So the Democrats in Congress created this statute, but some of them felt like it eventually came back to haunt them. They did feel like Ken Starr's investigation was the sort of scary scenario of an out-of-control independent prosecutor that Justice Scalia's dissent here had warned about. The Independent Counsel statute expired in 1999, and it was not renewed by Congress. So there is no special mechanism in place today for the appointment of independent counsel through joint action of the executive and judicial branch. However, the Department of Justice can still simply assign someone to do a particular investigation and call that person a special counsel or special prosecutor, even without having this specific statute under which to do it. And they do continue to do that from time to time. The most recent example was the appointment in 2016 of former FBI Director Robert Mueller to investigate issues concerning Russian involvement in the 2016 presidential election. Obviously, the debate about the virtues and risks of having independent or special counsel is still very much